Welcome to the Tejswi IP show. In this podcast, we dive into the world of intellectual property, like patents, copyright, trademark, geographical indication design. Also analyze the recent event in IP world. Hello, and thanks for joining us today. We're really digging into something pretty foundational, I think, for anyone creating, innovating, or building a brand today. Especially here in India, we are talking about intellectual property rights, IPR.
Absolutely. And it sounds quite technical, doesn't it? But understanding it is so crucial. It's really all about protecting the value of your ideas, your unique creations. I mean, the very identity of your business.
Exactly. And to help us navigate this, we're looking at the key insights from an article that really zeroes in on the top 10 advantages of intellectual property rights, specifically through the lens of India. It's almost like a roadmap, Understanding why securing these intangible assets is such a powerful strategic move right now.
That's right. Our mission today really is to unpack those advantages. What are the actual tangible benefits you get when you protect your intellectual property? We'll pull out the key points from this source material, try to give you a really clear picture.
Okay, so let's start right at the beginning then. What are intellectual property rights? The material we're using gives a pretty concise definition.
It does. It basically defines IPR as the legal protections granted to creators. So we're talking about the minds behind original works, inventions, distinctive brand identities, even confidential trade secrets.
And that phrase, legal protections, well, that's the really crucial part, isn't it?
It really is. That's the core of it.
It's not just, the act of making something new. It's the legal framework that surrounds it, that safeguards it. And this article highlights several specific types of IPR that are, well, particularly relevant.
Yes. It covers the main categories you typically encounter. So you've got patents, which protect inventions, trademarks, which are essential for brand names, logos, slogans.
Sure, brand identity.
Exactly. Then there's copyrights, covering original creative works, think books, music, software, films. It also mentions design rights for the visual look of products, geographical indications or GI tags.
Like Darjeeling tea, for instance.
Precisely. Linking products to a specific place known for quality. And finally, trade secrets, protecting that confidential business info. These are the kinds of assets we're talking about protecting.
Okay, so the fundamental power that IPR grants, as the source describes it, is this exclusive ownership and control over these intellectual assets. What does that exclusivity actually mean in the real world, for a creator or a business?
Well, think of it like owning a piece of physical property, like land. Exclusive ownership means you decide what happens there.
Right.
With intellectual property, it means you, and only you, have the legal right to use, make, sell, distribute, or license your patented invention, or your copyrighted song, or your trademark brand.
So you control it completely.
You control it. It gives you the legal authority to stop others from doing any of those things unless they have your permission. Your explicit permission.
Okay, so if I write a book and get the copyright, nobody else can legally publish or sell copies of that book without my agreement.
That's right.
And if I invent some, unique kitchen gadget and get a patent, I can stop other companies from making or selling identical ones, or maybe even very similar ones.
Exactly that. It essentially draws a clear legal line around your creative work or your invention. It transforms it from just an idea, which anyone could potentially copy, into a protected piece of legal property that you control.
Now, what I found really interesting in the material is the context it provides about India specifically. It seems like the IPR landscape here is changing fast, evolving. And there are some pretty compelling stats to back that up.
Oh, absolutely. The numbers aren't just figures on a page. They really tell a story. A story about growing awareness, increased activity, and a deeper recognition of just how important IP is within the Indian economy. Yeah. It shows this isn't just theory, it's actually happening.
So let's dig into those stats a bit. The article points out India filed, let me get this right, 61,573 patents in the fiscal year 2023-24. And it notes a pretty significant jump, a 13% annual increase. What does a rise like that signal? What's behind it?
Well, a 13% annual increase in patent filings. Now, that's a really strong sign of a healthy, thriving innovation ecosystem. It suggests that investment in R&D, research and development is growing.
Right, from companies and individuals.
Both established companies and, importantly, emerging ones. And even more crucially, it shows that the results of that R&D are being formally protected. People aren't just inventing. They're seeking patents for those inventions.
So there's more confidence in the system.
Exactly. It reflects growing confidence in the value and, critically, the enforceability of patents in India. and a desire to secure that competitive advantage that comes with novel technology.
Yeah.
It really points to India pushing forward in that global innovation race.
Okay, and it's not just patents. The material highlights huge activity in trademarks, too. Over 4.5 lakh, that's 450,000 trademarks registered in the same period. That number is staggering. What does that tell us about the Indian market?
That volume speaks, well, volumes, doesn't it? It points to intense market competition and a really strong strategic focus businesses are placing on branding.
Everyone wants their brand to stand out.
Precisely. Every single one of those 450,000 trademarks represents a business, could be large, it could be small, trying to carve out a unique identity, build recognition, and ultimately foster consumer loyalty in what's clearly a very crowded marketplace.
Yeah.
Protecting your brand name, your logo. It becomes absolutely vital when you have hundreds of thousands of other brands competing for attention. It shows a deep understanding that brand equity isn't just nice to have, it's a critical asset.
And here's a statistic that really caught my eye, kind of reflecting the new economy in India. Indian startups filed over 2,000 patents. That's a 5-fold increase since just 2017.
Wow.
5 times in about 6 years. Why are patents suddenly, or rapidly, becoming so important for startups?
Yeah, that 5x jump is remarkable. For startups, securing patents often isn't just strategic, it can be about survival and acceleration.
Survival, how so?
Well, a patent on their core technology can be a complete game changer. It gives them a defensible position, a shield against larger established players who might otherwise just copy their idea and crush them.
Right, stops them being imitated immediately.
Exactly. And crucially, as the article implies, it's a massive signal to investors. VCs, angel investors, they look for disruptive potential, sure, but also a clear path to market dominance, or at least a strong market position.
And a patent helps provide that.
A patent provides proof of novelty. It creates a barrier to entry for competitors. That makes a startup a much more attractive and, frankly, less risky investment. It's tangible evidence of innovation that goes way beyond just a slick business plan.
Makes sense. And it's not only the big tech or pharma companies or even just these venture-backed startups. The material notes that MSMEs, the micro, small, medium enterprises, and also those fast-growing D2C, direct-to-consumer brands, they're increasingly using IPR too. Especially trademarks, it seems, to build brand equity. What does that wider adoption tell us?
It really indicates a kind of democratization of IP strategy. It's not just seen anymore as something only relevant for the huge R&D heavy corporations.
Right.
MSMEs and DTC brands, they often thrive on that direct connection with consumers, building trust, building a relationship, their brand identity, their specific product designs, the whole look and feel, these things are paramount.
And they need to protect that.
They need to protect it. So legally protecting those elements is now seen as essential for safeguarding the value they build directly with their customer base. It means IPR is becoming a recognized, accessible tool for growth and security right across the business spectrum in India. Not just for the top tier anymore.
So if you put all these numbers together, the patent surge, the trademark volume, the startup activity, the MSME adoption, it paints a really clear picture. This isn't just legal theory. It's about a dynamic, growing ecosystem where protecting your intellectual assets is, well, becoming an absolute must for success, no matter your size or sector.
Absolutely. The statistics really underline that fundamental shift. IP used to be maybe an afterthought for many businesses now.
Yeah.
It's becoming a core part of business strategy, a core part of value creation in India today.
All right. So with that context set, let's get into the real heart of it. The 10 key advantages that this material lays out. These are the compelling reasons why anyone investing time, creativity, or money into innovation and branding really needs to pay attention to IPR.
Yes, these points offer a really comprehensive look at the returns you get from actually investing in intellectual property protection. Let's break them down one by one.
Okay, number 1. The first big advantage, and you could argue it's the most fundamental, is legal protection against infringement. The core idea here is simple. IPR gives you exclusive legal rights. That's your defense against unauthorized use, imitation, or, outright theft of your work or invention.
This is your primary shield.
Got it.
Absolutely. Without that formal legal protection, a registered patent, trademark, or copyright proving you own it and stopping others from copying you becomes incredibly difficult, sometimes impossible.
Yeah, I can
Your innovative product, your distinctive brand,
Yeah.
It could just be freely copied, undermining your market position before you even really get going.
And what does that unauthorized use actually look like in practice? How does it differ for, say, a patent versus a copyright?
Well, for patents, it might be a competitor reverse engineering your invention and then just producing their own version, straight up copying the tech. For trademarks, it's someone setting up shop or selling products using a brand name or a logo that's confusingly similar to yours. Maybe they do it deliberately, maybe not, but it misleads customers either way.
Right. And for copyright?
For copyright,
Oh, it could be someone copying your software code directly, distributing pirated versions of your film or your music, or maybe even plagiarizing chunks of your written work, all unauthorized copying.
the material gives a straightforward example, a registered trademark for a brand logo blocking competitors. Why is that ability to actually block competitors so valuable in practice?
Oh, that blockage is everything in a competitive market. It stops competitors from riding on the coattails of the goodwill and the recognition you've painstakingly built around your brand.
So they can't just benefit from your hard work.
Exactly. If they use a similar logo, customers might accidentally buy from them thinking it's you. That dilutes your brand, steals your sales. But with legal protection, you can issue a cease and desist letter. You can even sue to make them stop.
It ensures that when a customer sees your registered logo, they know it's uniquely your product or service, something they can trust. It safeguards your investment in building that identity.
So for anyone with a unique brand, a design, an invention, securing this legal protection is really the foundational step. It's the lock on the door that keeps what you create yours.
It absolutely is. It's the difference between having a brilliant idea and having a brilliant, legally defensible asset.
Okay, let's move beyond just defense. The second advantage highlighted is how IPR can actively boost revenue through licensing and royalties. So the idea is, once you own the rights, you can actually make money by letting others use your creations, generating income through royalties or licensing fees.
Yes, this is where your IP starts working for you as an income-generating engine. Instead of being the only one who can use your patented tech or your copyrighted book, you can grant permission that's a license to other parties.
Under specific terms, I assume.
Oh, absolutely, under specific terms. And in return, they pay you.
Yeah.
Often, this is in the form of royalties, which might be a percentage of the revenue they generate using your IP, or it could be a fixed upfront licensing fee.
So it's almost like renting out your intellectual property for profit. Is that a fair way to think about it?
That's a pretty good analogy, yes.
Yeah.
It lets you expand the reach and the impact of your IP without necessarily having to, scale up your own production or distribution endlessly yourself.
Right. You leverage other people's capacity.
Exactly. The material mentions software companies licensing tech through subscriptions or usage-based models. That's very common. You pay a fee to use the software. The company keeps ownership, but gets recurring revenue from you using it.
What are some other examples? How else might businesses use licensing besides software?
Oh, there are many ways. A company with a unique, patented manufacturing process could license that process to factories in different countries. A photographer could license their copyrighted images for use in advertising campaigns or websites. A creator who develops a really popular character could license the trademark and copyright for that character to companies making merchandise. Toys, clothing, games.
Like cartoon characters on lunchboxes?
Exactly like that.
Wow.
Or even a successful business model built on strong branding and know-how could be franchised. Franchising heavily involves licensing the trademark and all the associated intellectual property. In each case, the IP becomes a continuous source of revenue.
Wow. So this really shifts the perspective. It's not just about safeguarding what you have. It's about actively creating entirely new income streams based on your creativity and innovation. Your protected IP becomes a potential source of maybe even passive or at least diversified revenue.
Precisely. It allows you to extract value from your intellectual assets in ways that go far beyond just selling the final product or service yourself.
Okay, advantage number 3. This one focuses on how IPR enhances brand value and consumer trust. The argument is that trademarks and copyrights, especially, help build strong brand identities, and that leads to better recognition, customer loyalty, and a stronger position in the market.
Yes, a registered trademark, fundamentally, acts as a legal badge of authenticity. When consumers see a specific logo or name over and over again, and they associate it with a certain quality or experience, and they know that mark is legally protected, it builds trust. They understand this isn't some fly-by-night operation or a cheap imitation. It's the genuine article from a source they recognize.
How does the legal protection specifically build that trust, maybe more than just having a consistent but unprotected brand?
Well, the legal protection reinforces the idea of consistency and reliability.
Hmm.
If you see a famous protected brand logo on a product, let's say a trusted electronics brand, you have confidence it meets the standards you expect.
That's legally them.
Exactly. Without that protection, copycats could potentially use similar branding on inferior products. That would confuse customers, right?
Yeah.
And eventually erode trust in the original brand. Legal protection makes it much harder for that confusion and dilution to happen. It really solidifies that bond of trust between the consumer and the genuine brand.
The source material mentions Indian fashion brands like Fabindia and Manyavar. It notes their significant growth after they secured their trademarks and designs. How do you think protecting those specific types of IP likely helped them succeed?
Well, for brands like those, which are really rooted in unique aesthetics and designs, think Fabindia's handcrafted look or Manyavar's distinctive ethnic wear, protecting those designs and their brand names was absolutely critical.
Well, critical.
Because it stopped competitors from just, knocking off their signature styles or using similar-sounding names to confuse shoppers. By legally protecting their unique look and feel, they could cultivate a really clear market identity. They could build a loyal customer base who were specifically looking for their style.
And charge a premium, maybe?
And potentially position themselves as premium brands known for originality and quality. Protecting that core visual and brand identity gave them the solid foundation they needed to invest in marketing, to expand, knowing their distinctiveness was legally defended.
So it really isn't just about having a nice logo or a pretty design. It's about making that identity a legally defensible asset that customers learn to recognize, trust, and value. And that drives loyalty.
Absolutely. It turns your brand's reputation and recognition into a valuable piece of property.
Yeah.
Property that directly supports your market position and your customer relationships.
All right, advantage number 4. This one highlights how IPR encourages innovation and R&D. The core idea here is that knowing your innovations can be protected gives you the incentive you need to invest in what's often costly research and development. It helps foster a culture of creating new things.
Yes, and innovation is, by its nature, risky and expensive.
Right.
Developing something truly novel, a new technology, a new drug, a new process, requires a huge investment. Time, money, skilled people.
Yeah, it's not cheap.
Not at all.
Yeah.
And companies, or even individuals, just won't take that risk if the moment they succeed, anyone else can come along and copy it for free, with none of the upfront cost.
So how does IPR, particularly patents, I suppose, reduce that risk and provide the needed incentive?
Well, a patent grants the inventor a limited period of exclusivity. For utility patents, that's typically up to 20 years.
20 years.
During that time, they have the exclusive right to that invention. They can be the sole provider, or they can control who else gets to use it through licensing. This window, this period of exclusivity, provides the crucial opportunity to recoup that substantial R&D investment.
And hopefully make a profit.
And hopefully profit from the innovation before it eventually enters the public domain for everyone to use. It's that promise of a potential market advantage, a return on investment, that justifies the upfront cost and risk of doing the R&D in the first place.
It almost sounds like the patent system is a kind of bargain or a contract with society. You disclose your invention fully so others can learn from it eventually. And in return, society grants you this temporary exclusive right to exploit it.
That's a very good way of putting it. It's designed specifically to stimulate innovation by providing that temporary reward for the effort. And this is incredibly relevant for India, as the source notes, with its ambitions to be a leader in sectors like high-tech and pharmaceuticals.
Which rely heavily on R&D.
Exactly. Those fields are intensely reliant on continuous, very expensive R&D. Companies in those sectors absolutely need strong patent protection to compete globally and just to justify their long investment cycles.
The material also mentions government support here, like the Startup India IPR scheme. It offers an 80% rebate on patent filing fees. How does that fit in?
That's a crucial piece of the puzzle. The cost, and let's be honest, the complexity of getting patents can be a major hurdle, especially for, cash-strapped startups or individual inventors.
Yeah, legal fees can add up fast.
They certainly can. So by drastically cutting the official filing fees, the government makes the whole process much more accessible. It directly encourages more innovators to actually seek protection for their ideas. It helps them pursue R&D without being immediately put off by the cost of safeguarding the result. It's a very concrete way the government is actively supporting that innovation cycle.
So for anyone focused on inventing, creating new tech, new processes, IPR isn't just some legal hoop to jump through. It's really the essential safety net that makes pursuing those groundbreaking ideas economically viable in the first place.
It provides the very foundation upon which you can build a sustainable innovation strategy.
Okay, moving on to advantage number 5, competitive market advantage. The material says IPR helps businesses stay ahead by legally stopping competitors from using similar ideas, inventions, or even branding.
Yes, this is where that exclusivity we talked about becomes a direct, almost uh, weapon in the marketplace. It's not just about stopping outright theft. It's about actively carving out and defending your unique space.
How does having, say, a patent or maybe a really strong trademark portfolio give you that tangible edge over your rivals?
Well, a patent, as we discussed, can give you that temporary monopoly on a specific technology or feature.
Monopoly meaning only you can offer it.
Only you can offer that particular solution. This can lead to significant market share. It might allow you to command premium pricing because there's no direct equivalent available. And it gives you valuable time to build customer loyalty, refine your production, gain efficiencies before competitors can legally offer something similar.
And even then, they might have to invent around your patent. Right, find a different way.
Precisely. They often need to develop a different, potentially less efficient or more costly solution. Similarly, a strong, protected brand name stops competitors from confusing customers and essentially piggybacking on your hard-won reputation.
The example used in the material is about patenting a unique product formula or manufacturing method, creating that potential 20-year monopoly. That seems incredibly powerful.
It is. Imagine you develop a unique food ingredient or a much faster, cheaper way to manufacture something, and your competitors legally cannot copy that for 2 decades. That is a massive, sustainable, competitive lead.
It really sounds like, especially in crowded, fast-moving markets, IPR isn't just playing defense. It can be an offensive tool that legally establishes and protects your unique selling proposition.
It really shifts the basis of competition. Instead of just competing on price or maybe generic features that anyone can copy, you compete on the strength and uniqueness of your legally protected assets.
Okay, advantage number 6. And this feels like a big one for any business focused on growth. Attracts investors and business partners. The core idea is that protected IP adds real, though intangible value to a company, making it much more appealing to potential investors like VCs and also strategic partners.
Yes, investors are constantly assessing risk versus potential return. A company's IP portfolio gives them crucial insights into both sides of that equation.
How so?
Well, strong IP signals that the company possesses valuable, unique assets. And importantly, assets that are defensible against competition. This significantly reduces the investment risk. Why? Because the company isn't as vulnerable to being simply copied out of existence by bigger or faster rivals.
So how does IP specifically signal value and future potential to these investors? What are they seeing?
Investors look at a strong IP portfolio, maybe multiple patents covering key technologies, trademarks registered in key markets, perhaps protected designs. They see this as proof of innovation, proof of market foresight, and proof of a defensible business model.
It's more than just talk.
It's much more than just talk. These aren't just legal papers, they're assets. Assets that can generate revenue directly through sales or indirectly through licensing, or maybe even through future cross-licensing deals. They indicate the company has built something genuinely unique, something with lasting value and the potential for future growth and maybe even market leadership. It adds huge credibility and substance to the business plan.
There's a really compelling statistic mentioned in the source from a NASCOM and TIE report. It says startups with patents are 60% more likely to secure early-stage funding.
60%.
60% more likely. That's a huge difference. What's the main takeaway from a number like that?
That statistic sends a very, very clear message to startups. Invest in protecting your IP, and you dramatically increase your chances of getting funded. Period.
It quantifies the value.
It absolutely quantifies how much value investors place on patents as indicators of a startup's potential and its defensibility. It shows that having a patent isn't just, a nice-to-have checkbox. It's a critical factor investors actively look for when deciding where to place their bets. It significantly de-risks the investment proposition for them.
So if you're a startup founder, or maybe any business looking for that next round of funding or perhaps a strategic partnership, your intellectual property isn't just some line item on a balance sheet somewhere. It's actually a key part of your pitch. It demonstrates the inherent value and the future potential of your entire business.
It's tangible proof that you've built something unique and defensible in a tough, competitive landscape. And that makes you a much, much more attractive proposition for growth capital.
Okay, advantage number 7 facilitates international expansion. The material highlights that international treaties, things like the Madrid Protocol for Trademarks and the PCT, Patent Cooperation Treaty for Patents, make it feasible to protect your IP beyond India's borders. That enables global growth.
Yes, and in today's economy, that's crucial. Businesses sell online globally, they export goods, they offer services to international clients. If your business has any international aspect, your IP needs protection in those foreign markets just as much as it does here at home.
What's the challenge of doing that without these treaties? And how do systems like the PCT in Madrid actually simplify things?
Well, just imagine trying to file separate patent applications in, say, 150 different countries.
Wow. There.
Complete nightmare. Each country has its own language, its own fees, its own complex legal requirements, different deadlines. It would be prohibitively complicated and incredibly expensive for almost any business.
So what do these treaties do?
The PCT, for patents, streamlines the initial filing process. It lets you file one international application that effectively reserves your right to seek patent protection in a large number of member countries later on. It buys you time and centralizes the initial step.
Okay. And Madrid for trademarks.
Similarly, the Madrid Protocol lets you file a single trademark application in your home country and then designate multiple other member countries where you want protection. It's managed centrally through WIPO, the World Intellectual Property Organization.
So they don't grant like a single world patent or world trademark.
No, that's a common misconception. They don't grant a single global right, but they dramatically simplify the application process and significantly reduce the costs compared to filing individually in every single country. They provide a much more efficient pathway to getting those international legal rights established.
How does this directly help Indian businesses looking outwards, maybe exporters or those SaaS software companies serving global clients?
Well, for an Indian company exporting goods, having their trademark protected in the countries where they sell is essential. It stops counterfeiters from using their brand name and ensures consumers abroad recognize the genuine product.
Builds trust internationally.
Builds trust, exactly. For a SaaS company with users all over the world, protecting their software technology through patents and their brand name through trademarks in key international markets is vital. It prevents unauthorized copying, helps them defend against infringement lawsuits, and is just fundamental to building a credible global presence. International IP protection isn't really an option anymore. It's basically a prerequisite for scaling successfully in the global market.
So for any business with global ambitions, understanding and using these international protection systems isn't just beneficial, it's a necessary strategic step. And these treaties make it significantly more manageable.
They really provide the legal infrastructure you need to grow your business and your brand footprint together, hand in hand, across borders.
Right, okay. Advantage number 8. This one is tied directly to the financial health and the future exit possibilities of a company. Increases company valuation. The material states that intellectual property is a type of intangible asset, and it adds significant value to a company's balance sheet. This boosts valuations during things like mergers, acquisitions, M&A, or even initial public offerings, IPOs.
Yes. When a company is valued, especially for a major transaction like a sale or going public, the assessment goes way beyond just the physical assets, the buildings, the equipment, or even just the current year's revenue.
Intangibles matter more now.
Intangible assets represent a huge, often the largest portion of a company's true value in the modern economy. Think brand reputation, customer relationships, proprietary technology, and crucially, legally protected IP.
So how does having a strong IP portfolio actually translate into a higher price tag for the company?
Because buyers and investors aren't just buying the company as it is today. They're buying its future potential and its market position. A strong IP portfolio signals that the company has unique technologies or a defensible market niche, significant brand recognition built up.
Potential future inflow streams, too.
Exactly. Potential future revenue streams from licensing or from new products developed based on that core IP. It demonstrates barriers to entry for competitors, showing a sustainable competitive advantage. All of this makes the company intrinsically more valuable to a potential buyer or to public market investors. They're acquiring assets that underpin future profitability and market leadership.
So it's heavily scrutinized in deals.
Oh, absolutely. During the due diligence process in an M&A transaction, the strength, the breadth, the enforceability of the target company's IP portfolio are intensely examined. A well-protected, valuable IP portfolio can justify a much, much higher purchase price or IPO share valuation compared to a company with similar revenues but maybe easily imitable products or weaker branding.
So for any business that's aiming for growth, for scale, and maybe eventually for a liquidity event like being acquired or going public, building and diligently protecting a robust IP portfolio is actually a direct investment in increasing the company's ultimate worth.
It's about fundamentally recognizing that your ideas, your inventions, your brand, they aren't just operational elements. They are valuable, potentially sellable assets in their own right.
Got it. Advantage number 9. This highlights how IPR builds a reputation for creativity and quality. The idea here is that brands associated with unique, protected products or services gain trust, they gain recognition, and often they can command premium pricing as a result.
Yes. When you take the step of protecting your unique creations through IP, you're sending a signal to the market. You're saying we are original, we are innovative, and we're serious about the quality and distinctiveness of what we offer.
And consumers pick up on that.
Consumers often associate legally protected brands or products with authenticity, with reliability, maybe a higher standard, because they know it's the genuine article, not just a copy or an imitation.
How does that link between protection, originality, and quality lead to trust, and then maybe the ability to charge a bit more?
Well, trust is usually built on consistency, consistently delivering value. Protecting the IP that underpins your unique value proposition, whether that's a special design feature, a unique process, or just a highly trusted brand name, it helps ensure that consumers consistently get the authentic experience they expect from you.
Right.
This helps make your brand synonymous with originality and quality in the consumer's mind. And that differentiation, being seen as unique and trustworthy, allows you to stand out from maybe more generic competitors. And that often justifies premium pricing. People are frequently willing to pay more for the assurance of authenticity and the unique value they associate with a protected brand or innovation.
The material gives examples like Amol with its GI tag, Tata with its trademark, and Biocon with its patents. How are their reputations tied to their specific IP?
Those are great examples. Their reputations are deeply intertwined with their IP. For Omol, the geographical indication reinforces its connection to specific regional quality standards, which is core to its identity. For Tata, the sheer enduring power of its registered trademark signifies decades of trust and quality across incredibly diverse industries. It's a mark of reliability.
And Biocon?
For Biocon, their extensive patent portfolio is direct evidence of scientific innovation and excellence. That builds crucial trust in their complex biotech products. You see how this specific type of IP aligns with and actively strengthens their distinct reputation in the market.
So if you want your brand to be known not just for what it sells, but for being original, for quality, for authenticity, protecting the IP behind those qualities is a really crucial step in building that story and justifying the value you offer.
It solidifies your brand's narrative and makes your unique selling proposition legally defensible and clearly recognizable to your customers.
Okay, and finally, advantage number 10. This brings us kind of full circle back to the practical reality of defense. Helps in legal enforcement and recovery. The material states that having protected IP gives you a strong legal foundation to actually take action against infringers. You can seek remedies like cease and desist orders or maybe even financial compensation.
Yes, this is where the rubber really meets the road. That legal protection, that registration certificate, it isn't just a piece of paper for the wall. It's the basis for taking decisive action when someone violates your rights.
So if you find someone copying you,
If you discover someone is infringing your patent, your trademark, or your copyright, your registration provides the clear legal standing you need to pursue enforcement. You don't have to start from scratch trying to prove ownership.
what does having that strong legal foundation, as the source puts it, enable you to do specifically when you face infringement?
Well, crucially, it means you don't have to waste time and resources just trying to prove you own the rights or prove your creation is original. The registration itself is powerful evidence of that. So you can confidently issue cease and desist letters, demanding the infringers stop their illegal activities immediately. If they don't comply, you have clear legal grounds to file a lawsuit.
Can in court.
Through litigation, you can seek injunctions. Those are court orders to force them to stop the infringement. And importantly, You can pursue damages. That means seeking financial compensation to recover the profits the infringer might have made from copying you, or the losses you incurred because of their actions. You might even be able to recover your legal costs.
And without registered IP.
Without registered IP, enforcement becomes vastly more difficult. Often, practically impossible. It's very hard to argue someone copied your trademark if you don't have a formally recognized legal claim to that mark in the first place.
The material mentions the role of professionals, like patent attorneys, in this enforcement process. How do they help leverage this advantage?
Yes, legal professionals who specialize in IP are pretty much essential here. Enforcement proceedings are complex. They require deep knowledge of IP law, court procedures, evidence rules.
Not something you'd want to DIY.
Definitely not advised. A patent attorney, for instance, knows how to gather evidence of infringement, how to analyze the scope of your patent claims against the product that's copying you, how to graft effective legal demands, and ultimately, how to navigate the litigation process to enforce your rights and maximize your chances of recovering damages. They are the experts who can effectively wield the legal power your registered IP provides.
So the act of protecting your IP is intrinsically linked to your ability to actually defend it legally and maybe seek compensation if someone does copy or misuse your valuable creation.
It ensures that your rights aren't just theoretical concepts. They're backed by the full power of the legal system, giving you the actual means to fight back and protect your market position and your reputation.
Now, the material also briefly touches on the ways the Indian government is actively supporting IP growth and protection, which we sort of touched on earlier with R&D.
Yes, and these support mechanisms are really important for making the whole IP ecosystem more accessible and more effective for everyone.
Beyond that, Startup India scheme's 80% patent fee rebate we talked about, it highlights things like IPR awareness programs run by government bodies like DPIIT and CPAM, and also patent facilitation centers, which offer legal help specifically to MSMEs and academic institutions.
Right. And these initiatives tackle different parts of the challenge. The awareness programs are vital just for basic education, letting potential creators and businesses know why IP matters and how the system works. It helps demystify the whole process.
And the facilitation centers.
The facilitation centers provide practical, often subsidized legal help. This makes the sometimes complex process of actually filing and managing IP rights much more manageable for smaller businesses or research institutions that might not have their own in-house legal teams.
So it seems these support structures are actively working to make all these advantages we've discussed more attainable for a much wider range of creators and businesses across India.
They really represent a clear governmental commitment to nurturing innovation and creativity by strengthening the framework needed to protect their output. It's quite encouraging.
So, summing everything up then, the material gives us a really comprehensive picture. Protecting intellectual property in India today is clearly far more than just some legal compliance item you tick off a list.
Oh, absolutely. It's clear the benefits touch pretty much every aspect of a business or a creator's journey, from the most fundamental defense right through to significant growth opportunities.
Yeah, we've seen how it provides that absolutely necessary legal shield against copying, how it can open up entirely new revenue streams through licensing, how it builds invaluable brand value, and that all-important customer trust.
And how it fuels future innovation by de-risking R&D investment, provides a critical competitive edge in the market, facilitates essential international expansion.
Right, and even directly increases a company's financial valuation, helps build that reputation for being creative and high quality, and finally gives you the actual legal power to enforce your rights and recover losses if someone does infringe.
It really paints a picture where protecting your IP isn't some kind of sideline activity. It's a core strategic imperative for anyone who's serious about scaling their business, monetizing their work, innovating consistently, and simply standing out in today's competitive landscape.
And the material really reinforces that India's IP landscape isn't static. It's changing, it's evolving rapidly, legal frameworks are strengthening, and these government incentives are making it an increasingly opportune time, it seems, for creators and businesses to actually invest in identifying and safeguarding their intellectual assets.
It definitely suggests the environment is becoming more supportive and potentially more rewarding for those who take their intellectual property seriously.
Which leaves us with a kind of key question, doesn't it? Something for you, the listener, to maybe consider as you think about your own work or your business or any creative or innovative projects you're involved in. Given this wide range of advantages we've just explored, everything from basic legal defense all the way to boosting revenue and attracting investment, and considering the increasing support available within India.
Yeah, the question becomes, how might you go about identifying the intellectual assets you might already be creating? Maybe things you haven't even fully recognized have potential value yet. And then what steps could you take to actually protect them?
Or perhaps, put another way, what untapped potential might be lying dormant right now within your unique ideas, your designs, your inventions, maybe even your developing brand? Potential just waiting to be unlocked and leveraged through the power of intellectual property protection.
It's definitely a valuable question to ponder, especially in this innovation-driven era we're in.
Thanks for listening. Stay tuned for more upcoming episodes.